The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases are scheduled to be submitted this morning. Those cases are State of Iowa versus Marvis Luttrell Jackson. Second case is State of Iowa versus Stephen Scott Prussia. And the third case is Regional Utility Service Systems versus City of Mount Union. That last case is submitted to the court at this time without argument, and we'll hear the arguments in the Jackson case. Ms. Wilson.
May it please the court. My name is Theresa Wilson. I'm here today presenting argument on behalf of Marvis Jackson. He was convicted of 2 counts of robbery in the 2nd degree following a bench trial on the minutes of testimony. He challenges the district court's denial of his motion to suppress. The question before this court is whether the search of his bag, in which a gun and other items were found, was done with valid third-party consent. It is raised in the context of both the federal standard of apparent authority and a claim of ineffective assistance of counsel for not arguing actual authority under the Iowa Constitution. Even under the more relaxed standard of apparent authority, the record reveals the officers in this case failed to appropriately inquire when they were confronted with an ambiguity over the premises. Fourth Amendment obviously provides protection against unreasonable searches and seizures. The question is whether there is a legitimate expectation of privacy in the property. The status of an overnight guest is sufficient to establish an expectation of privacy. This includes specifically the privacy in any items that guest happens to bring into the homeowner's residence. If there is a warrantless search of that property, we have to ask whether an exception applies. Consent is certainly an exception. Under Matlock, consent can be common authority with a third person. This means mutual use of property by persons having joint access or control for most purposes. The theory behind this is that when 2 people share a space or premises, the first person relinquishes a little bit of their expectation of privacy and assumes the risk that the other person will allow inspection of the space. But still, the guest retains privacy in their own items in their exclusive possession. The Fourth Amendment goes a little bit...
In this case, the backpack was in the closet, and it was Olson's room, right?
Correct. It was maybe just on the outskirts of the closet, but it was in the room, and I am absolutely not disputing that Olson had consent to search his room. The problem is when we get to the specific question of the backpack.
Well, isn't there a question of whether or not the police can rely on the good faith exception? You know, that they thought they had permission to search everything in the room, including the backpack? I mean, are we going to extend the good faith exception to allow them to search the backpack?
Under Rodriguez, that is the standard in the federal system, and a number of states have accepted it, and a number of states have rejected it. We are certainly arguing that this court, under Article 1, Section 8, should reject apparent authority in favor of actual authority. It is more consistent with our case law, and it is more consistent with the rationale of cases where we, for example, rejected the good faith exception.
Are there any states, you know, we've rejected the good faith exception in Klein as the search warrants. Are there any states that have accepted the good faith exception who have rejected the good faith exception dealing with search warrants?
That I am unclear on. I know there are a number of cases that have rejected the good faith exception under the exclusionary rule and have since rejected the good faith premise in Rodriguez. The ones who have rejected apparent authority are Montana, Hawaii, Oregon, New Mexico, and Washington.
They have the good faith exception with dealing with search warrants. I mean, I think it's important that, you know, we've had a long good faith exception, we have not accepted the good faith exception with search warrants. And now, do those states who do that follow through on the apparent authority issue?
Yes,
Rejecting
yes.
the good faith?
Yes, okay, I think,
Trying to get at?
yes.
I don't think it's right to compare how many states rejected and accepted it, because if you accept it in search warrants, it really is not a good comparison.
Well, and I think Lopez is somewhat helpful. That's out of Hawaii. They rejected the good faith exception under the exclusionary rule because for them it wasn't about just deterring police misconduct. It was about protecting constitutional rights. In Iowa, we have, in rejecting the good faith exception here, we have said it's not just about deterring police misconduct. It is about also the integrity of the judiciary and in protecting constitutional rights. We don't want to dilute those rights. And so the states, like Hawaii, who have rejected the apparent authority doctrine, have done so because they do not believe that the apparent authority doctrine properly protects individual rights, doesn't give a defendant a remedy, and they construe their provision as much more protective of the home, just like we do.
Isn't there a difference between the good faith exception to the exclusionary rule, which it basically holds the law enforcement did something that was wrong, they did something that was not in compliance with the law, but we're not going to apply the exclusionary rule, and apparent authority, which apparent authority is good authority under our legal system, isn't it?
I would argue not under the
Well,
Iowa
let me give you an example. Let's say Olson sells the backpack to somebody for $100, or say he sold it to Smithy in this case. That's a binding contract, assuming he had apparent authority. I understand your first argument that he didn't have apparent authority, but that would be a good contract, wouldn't it?
I assume so, and he would no longer have any expectation of privacy because he turned over his interests. But
Well, it's true. It's true under Illinois versus Rackus that search and seizure rights are personal to the accused and cannot be vicariously asserted, right?
right.
So why could you vicariously assert consent?
Well, and that kind of goes to the whole purpose of third-party consent and why apparent authority is completely inconsistent with it. When we're talking common authority and third-party consent, we're talking about assuming the risk that somebody you gave permission to or access to or mutual use with your property could allow others to have access to it.
I mean, it seems to me all the cases prior to Rodriguez focused on the individual. I mean, we talk about Stoner, we can talk about Matlock. It focuses on the individual and whether that person gave up his personal rights.
Yes.
And isn't that the focus of this entire process? I mean, if you waive your Fourth Amendment rights, I mean, Justice O'Connor says it in Bostwick, you waive your search and seizure rights, and the search and seizure restrictions don't apply anymore. I mean, you consent, you waive, they're gone.
Right.
So shouldn't the focus be on the individual, just as it is in our standing cases that say the individual has to assert their own personal rights? Doesn't it follow from there that if you're going to give consent, it's got to be personal?
Right, and again, apparent authority makes the assumption that somebody has the right to consent who doesn't. Basically, it renders what is otherwise invalid consent valid for Fourth Amendment purposes. And I don't care whether we put the good faith analysis at the beginning of the search and seizure analysis or at the end of it. That intrusion is still an intrusion onto that person.
Let me give you a hypothetical. Is the rule of law that you're advocating for, does that mean then that if the police are, going door to door for some reason, let's say there's some incident like some of ones that have happened recently in the news, and they knock on the door and the person opens the door, they have to say, can you show me an ID and let's check the property records to make sure you own the property?
No, they just have to make reasonable inquiry. And that's the thing.
But if they, but I thought that's a separate argument. I thought you're saying that I thought your argument is even if there's apparent authority, you have to have actual authority. And reasonable inquiry doesn't necessarily get you to actual authority, right?
But sometimes it does. And here's the thing. Had these officers bothered to ask the necessary questions, not only would they have gotten to apparent authority, potentially, or clarified there was no apparent authority, but they may well have gotten to actual authority.
But under your theory, even if Olson had said, yes, that's my backpack, I own it, you'd still be here arguing the same thing, right?
Not necessarily. Well, Waller, if you look at Waller out of the Sixth Circuit, it was a case where there was a bag in somebody else's home, and that case stood for the proposition that if there's a possibility that somebody else might have possessory interest or privacy interest in this bag, then the officers should inquire. There are two men in this room. Either one of them could have had access, could have had mutual use, but it happened to belong to the defendant. All the officers had to do was ask the question of, to the defendant even, do you have any belongings in this room? Whose bag is this? They would have been able to find out that answer. They didn't do that. And there is a lot of ambiguity. I don't understand how this case is supposedly less ambiguous than Grant. In Grant, the officers don't initiate anything. The homeowner comes to them and says, I have guests in my apartment, and they've brought a gun in, and I want it removed. So the officer goes to the apartment, finds the couple. They're obviously asleep in the bedroom. There are male and female possessions in the room. And they conduct a search of the jacket, and it's thrown out because that was an ambiguous situation. Well, it really wasn't ambiguous because the officers should have known they were guests. The owner told them. And the circumstances they were provided with showed that they were guests. They had belongings there. Here, they do ask the two men, the two roommates, all right, who lives here? Well, just me, my roommate, and my roommate's girlfriend. Both of them say that. Then they ask Olson, can we search your room? Oh, wait, my cousin's in there. Well, he's not really my cousin like that. That should have caused an immense amount of suspicion on the police officers that the circumstances they thought they were initially faced with has now changed. They're already suspecting at least two people involved in a robbery. So it would appear that people are not being very truthful with them. Turner doesn't even tell the officers initially that Mr. Jackson is in the bedroom, even though he goes back into the bedroom to get Olson and should have seen Jackson. Certainly, Officer Smithy, when he goes back to the room, sees Jackson as soon as he looks in the door. So the officers had reason to question. But again, we do suggest that this case should be decided under Article 1, Section 8 as an actual authority case. And I do want to point out Commonwealth v. Porter, because I think it's very appropriate in light of our decisions that have said that we respect the privacy and sanctity of the home, and explains why the search in this particular circumstance may not have been valid. In Porter, that was a case where the Massachusetts Supreme Court adopted the apparent authority standard. Now, part of it was because their constitutional provision is very similar to and was adopted at the same time as the Fourth Amendment, so they give great deference. But then they provide this analysis. They say we have 3 exceptions allowing for a warrantless search of a home. Those 3 are exigent circumstances with probable cause, emergency aid, and consent. They say, we've already allowed good faith mistakes by officers to validate a search under the first 2 exceptions, so we're just going to go ahead and use good faith to validate consent for apparent authority purposes. There is an inherent difference between those exceptions, particularly when you're talking about the home. because both probable cause with exigency and emergency aid generally require immediate action. And we can see with the balancing, the public interest, the individual's right. If there's an emergency, we may want to give a little bit more leeway to officers.
Of course, you still have to have probable cause.
Yes,
In terms of the ordinary exceptions, exigent circumstance and so forth.
Right.
The notion is that you can't get a warrant, you don't have enough time.
Yeah.
And courts generally, and I think we have too recognized that. But isn't that far afield from consent? Consent takes you completely outside the warrant requirement, frankly, it seems to me. Correct me if I'm wrong, but the issue here isn't really, is there an exception to the warrant requirement? Should we go down to a magistrate? The question is whether a person says, maybe I have my rights and privacy, but I surrender, I give them up, I give consent. And at that point, it seems to me, we're at the end. I mean, frankly, search and seizure law no longer applies.
yes. I mean, the whole, consent can be a very general exception, which is why it should be narrowed significantly. And particularly when a person has not specifically authorized another person to give consent on their behalf, or when there is no emergency. If we allow the apparent authority exception, we're going to allow a lot of intrusions into the home that we never envisioned, probably.
Well, but we already accept the apparent authority doctrine. We've already accepted that in our cases before. Now you're asked, and that's, I'm looking at State versus Lowe, where we say authority to consent includes not only actual, but also apparent authority, and we cite to Rodriguez. And we've already recognized this as being here. You're asking now for something, again, a different interpretation under our Iowa Constitution, to now go to this other standard, which is actual authority. You must always have actual authority. And that's going to be, again, a significant change from what we've already said within the last 3 years. I'm having a little bit of trouble under these set of facts of saying that this is the method by which we ought to resolve that problem in this case.
Your Honor, respectfully, I'm not asking you to adopt a new standard. I'm asking you to go back to an old one. It was actual authority under Matlock. And the cases that Iowa has decided have not been under the Iowa Constitution. They have all been under the Fourth Amendment because nobody's asked for a different standard until today. For those reasons, we'd ask for reversal.
Thank you, Ms. Wilson. Ms. Hall.
May it please the court. Turning first to the question of whether defense counsel should have urged the trial court to adopt an actual authority standard under the Iowa Constitution, the state would urge this court to reject defendant's invitation to do so. First, if we look at Illinois versus Rodriguez, in that case, the Supreme Court held that the Fourth Amendment does not require factual accuracy, but that the officers must exercise reasonable judgment in considering whether a third party has authority to consent to an entry and or search.
That's all true.
Isn't that just another way of saying they have to have good faith, that they made the reasonable inquiry in good faith? In the search warrant, we say the same thing. They have to have good faith. The search warrant's good, but if it's a technical defect, we suppress the evidence. I mean, so what's the difference?
Your Honor, the state believes that there is a definite distinction between the good faith doctrine and the apparent authority doctrine. In Rodriguez, the court did not discuss or rely on the good faith principles from its earlier decision in U.S. versus Leon. This makes sense because the good faith exception to the exclusionary rule was based on an officer's mistake of law as to the validity of a search warrant, while the apparent authority doctrine is more often based on an officer's reasonable mistake of fact.
Wasn't this a mistake of law? The mistake of law was the officers didn't know what Minnesota v. Olson said, namely that a guest has privacy rights, and the officers apparently didn't know the result in Randolph, which says when there's differences of opinion as to search, the party that declines the search will prevail. It strikes me, this distinction between fact and law doesn't really wash.
We think it does, Your Honor.
Did the officers realize what Minnesota v. Olson stands for? And I think it stands for, I invite you to correct me, but I think it stands for the proposition that a house guest has privacy rights. As I look at the record, there was question about, well, who's living here, who's not living here, and so forth. But that's not the issue. This person was a house guest. He was curled up in the bed. Surely gives a suggestion that they're a house guest. If they knew Minnesota versus Olson, they would have known as a matter of law that that person has privacy rights, and we probably wouldn't be here today. So, isn't this really apparent authority has factual issues, frankly, and legal issues. If you don't have the right legal framework, you're not going to decide, the factual issues won't be properly resolved either. But I retreat to the notion that the real problem here was not knowing what Minnesota v. Olson stands for.
I would, as a factual argument, I would disagree that these officers reasonably believed that he was, in fact, a house guest. The officers were tracking 2 black male robbery suspects directly to that apartment building. Looking up, they saw a black man intently looking out the window at them. As soon as he saw they made eye contact with him, he backed up, turned off the light. Officers approached the door. They heard the door lock. They knocked. Turner answered the door. He was the one looking out the window, said that he lived there with his girlfriend and Gunnar Olson. Turner was, in fact, Jackson's partner in the Gumby's Pizza robbery. When they talked to Olson, he did not mention that any other person was living there or staying there, but that he had woken up to find his cousin or a man that wasn't his cousin sleeping next to him, and he didn't know when he had arrived. And even though Jackson was only wearing pajama pants, officers found it unusual that he was sweating and that he was pretending to be sound asleep, further supporting their belief that the robbery suspects were, in fact, 2 of the men in that apartment. When Jackson was aroused, he said he did not have an ID, but provided his name. His ID and wallet were, in fact, in the backpack. Jackson was arrested then at that time when officers discovered an outstanding warrant for the unsolved November gas station robbery. And then he was removed from the room, but he was not removed in an effort to prevent him from objecting to a search request.
What's wrong with, I think we have a good feel for all the facts, but what's wrong with the requirement that the police make further inquiry as to who actually has ownership of the backpack for purposes of obtaining consent to search it?
Well, there's no problem with that, but the officers didn't have any idea that Jackson had any belongings in the room. When he was arrested and taken from the room, he did not ask to retrieve any belongings, apparently to abandon his backpack.
But correct me if I don't have the facts right, but he's in pajamas, he's in the bed.
The officers could not remember whether he had put on any other clothing. Well, we know he didn't put on his jeans were in the backpack, but perhaps he had a shirt.
Doesn't it give rise to some reasonable inquiry of what's going on there and what's, and the backpack is in kind of close proximity to this guy who's in bed? Maybe he's faking sleeping, maybe he's not, he's in his pajamas. My heavens.
Actually, we don't believe that the backpack was in close proximity to the
How
air
far
mattress
was it?
where he was.
Yeah, how far was it? 100 feet?
Unfortunately, the only photographs taken were after the officer picked it up from the edge of the closet and put it on a chair. So all we know is it definitely wasn't next
In the
to
room.
the air mattress where he was sleeping.
Okay.
So our argument on the facts is that under these circumstances, the officers were reasonable in believing that Olson had the authority to consent to a search of everything in his room. He told the officers he lived there alone.
Let's talk about the law a little bit, going back to Illinois versus Rodriguez. If you look at the dissent in Illinois versus Rodriguez, doesn't the dissent really track our case law? In short, for example, we talk about the need for a search warrant ordinarily in searching a residence, talk about the need to get a magistrate and so forth. When you look at what Justice Marshall wrote in dissent in Rodriguez, frankly, they're quite similar. The majority opinion in Rodriguez relies on kind of a freestanding reasonableness doctrine, but that is not what State v. Short embraces. So if you, analytically, hasn't our case law evolved in a direction much closer to the dissent in Rodriguez than the majority opinion?
Well, the search and seizure law has evolved more arising from the Iowa Constitution. However, Short was a case that did not involve consent as an issue.
Well, it didn't. Absolutely correct. But it did emphasize that reasonability is determined in part by whether or not there was a warrant application and so forth and so on. That reasonability is not a freestanding concept, and that's exactly what Justice Marshall says. And also emphasized the desire to have judicial magistrate review of findings of probable cause. So I guess I want you to try and persuade me that, well, our law really hasn't evolved away from Illinois versus Rodriguez.
Well, especially in State versus Lowe, where this court, as recently as 2012, had discussed both the actual and apparent authority doctrines, upholding a search based on a co-tenant's consent to search a container in a common area. And as discussed in the amicus brief filed...
Yeah, but in Lowe, we did not reach the Iowa constitutional question. I mean, Rodriguez is right. There's apparent authority, but we still left open the application, which we're here today. And tell me why we shouldn't adopt get rid of this good faith thing and require actual authority and reject the apparent authority under the Iowa Constitution.
Our argument is that Rodriguez and the apparent authority doctrine is not the same thing as the good faith exception. That you need to focus on the difference between mistakes of law and mistakes of fact. At least 10 states have found adoption of the apparent authority doctrine consistent with the search and seizure clauses of their state constitutions.
And in those states,
noting the distinction.
In those states, did they have the good faith exception? I don't think so.
Actually, there are 3 of them. Of those 10 states, they have specifically discussed the distinction between mistakes of fact and mistakes of law and why the apparent authority is different from the good faith exception.
I think Idaho is one of them.
Idaho's the...
Those 3 states are Idaho, Pennsylvania, and Massachusetts, and they have declined to recognize the Leon good faith exception as this court did in State versus Klein. But they do apply the apparent authority doctrine. Of the 6 states rejecting the apparent authority doctrine in favor of actual authority standard, 3 of them, Hawaii, Montana, and Washington, have search and seizure provisions where the language specifically provides for greater privacy rights than the Fourth Amendment or our search and seizure clause.
Aside from the case law, let me just ask you analytically. It seems to me, at least in Leon, we rejected it, of course, but at least in Leon, you had a search warrant application. Our law tends to favor search warrants, it seems to me. That's what I gather from Short. We want to encourage officers to get search warrant. Here, we don't have an application for a search warrant. So doesn't that make this case even less strong than Leon in terms of trying to avoid consent?
Actually, I think the facts are stronger because Olson clearly indicated that this person was not expected to be here, no indication that he's a guest by either of the apartment residents. He gives consent to...
Was he there without their consent? He's sleeping in the bed? Well,
he came in with Turner, who was his partner in the robbery. But police thought that he wasn't staying here. He had just run in here, laid down, and pretended to be asleep. If they had asked Jackson, do you have any belongings in this room before they put the handcuffs on him and took him out, he would have said no. He was not going to claim the backpack with the jeans and the gun.
We don't know that, I guess.
And Olson, it's more likely that he hadn't even noticed that Jackson had brought anything into his room because he had just been woken up himself. And if he had been specifically asked, is everything in this room yours, he may or may not have looked at the backpack and said, I don't think that's mine. Then the officers would not have had actual authority at that point either, and they would have had to go get a warrant, which they did as soon as they opened the backpack and saw the gun.
What do you
Ms.
make
Wilson,
of the?
It seems to me that most of our exceptions onto the warrant requirement seem to be built on the reasonableness analyzed in the context of the interests of the state and the need to search versus the privacy interests of the people involved. But when we're talking about consent here, is consent a real exception to the warrant requirement, or is it just a doctrine that's independent? It just takes us out of a constitutional analysis and you go into a contractual type analysis. So how do we really analyze the issue of consent?
Well, if you have valid voluntary consent, then a warrant is not required. So in that sense, it's...
Not only a warrant is not required, but reasonableness doesn't kick in, and the Fourth Amendment protections and Article 1, Section 8 protections are not implicated.
Correct.
It's not a reasonableness issue, and it's not a warrant issue. It's a fact that the privacy interest which inheres in the individual, he or she chooses not to search them. And consent doctrine says, well, then the search and seizure doctrine is not applicable.
The state's argument, again, is that the apparent authority doctrine does not allow carte blanche consent entries if the circumstances, when viewed objectively, are ambiguous. Officers have an affirmative duty to make further inquiries in an effort to resolve that ambiguity. This doctrine, we believe, strikes a reasonable balance between the state's interest in preventing crime and an individual's interest in privacy, and we would ask the court not to overturn that in this case.
Thank you. Ms. Wilson.
May it please the court. With respect to the state cases, the state and amicus point out that a number of state constitutions where they have rejected the apparent authority doctrine talk about or have specific provisions regarding invasions of privacy. That's placing form over substance because privacy is subsumed in the Fourth Amendment. We would not be talking about the Fourth Amendment if we were also not talking about expectation of privacy. So I think we have to assume that privacy is inherent in Article 1, Section 8. As far as the factual scenario presented to the officers, yes, when the officer steps into the room, he sees Mr. Jackson in his pajama bottoms. And the state argues that, well, he suspected something because the defendant was sweaty. Well, wouldn't you also suspect something because he's half naked? Where are his clothes? If they're not in the room, they're going to be, if the clothes aren't strewn about the room, they're probably in a bag somewhere. That should have given officers reason to believe that he had clothes in the room. And in fact, I believe it's Officer Smithy testified that they allowed the defendant to put on clothes before he left the room. Where did those clothes come from? He's obviously not in the interview naked, so he got clothes from somewhere.
Assuming the standard is not metaphysical certainty, you would agree with me that under an apparent authority analysis, the question is, was it reasonable for the officers to conclude that the backpack belonged to the owner of the room, right?
The standard is whether it's reasonable to believe that the roommate had authority to consent, yes.
Okay, you're right. You're correcting me, and that's a good correction. And wouldn't that be a reasonable conclusion under these circumstances where the roommate says, it's my room and this guy just showed up, and however far away, it's not next to the bed and it's in a closet or just inside the open door of the closet?
Technically, I think Officer Smithy said it was 5 feet from the bed. No, it's not reasonable, because first of all, the roommate has already been less than honest about who's in the room up front. Then, how does Mr. Jackson get in the room? And contrary to what the officers may have thought, okay, Olson's telling them, I don't know how he got in the room. Well, he either got in then through Mr. Turner, or Ms. Miller, I guess, the 2 other people in the residence, or did he have a key? All of these things should be going through the officer's mind if Olson's telling the officers, I don't know how he got here. He's obviously not upset about Mr. Jackson.
Counsel, is it your position that under an objective test, it was ambiguous whose backpack that was, or ambiguous whether Olson had consent to search, to authorize a search of the backpack, right?
That is definitely the standard, yes.
And if we agreed with you, then we would have no reason to reject the apparent authority doctrine. We just apply it and say they had a duty of inquiry. Should have asked, is this your backpack, right?
Yes.
So this case could be decided quite narrowly and specific to the facts, yes?
Absolutely. Only if the court wanted to provide some guidance for future cases is the standard we want to use under the Iowa Constitution. Do you have to go there? But if the facts as I'm presenting them do not allow for a reasonable belief that Olson had consent, you don't have to go to actual authority. The items resulting from the search were used to obtain statements from Turner and Olson, and those statements were used, and the evidence was used to obtain statements from the defendant, and the items from the search were also used to get the search warrant. So for those reasons, everything that was taken or found in the search and all illegal fruit should be suppressed. Thank you.
Thank you as well. State versus Jackson is submitted, and we'll now hear State versus Prussia.